Thank you very much, and I must say it's a great honor to receive this award, both because of the very exalted individuals who have received it in the past, and more importantly, because in reality, I received this award on behalf of many people. Any success that I have had in my career has been the result of collaboration with dedicated and talented professional colleagues. And those have included many interns from Case Western who have played a vital role at the Special Court for Sierra Leone, including many of them who are here today. And it is truly those individuals who deserve most of the credit for whatever success I have had, and I thank them very much. It is a privilege to be here today to speak with all of you and to tell you about the challenges that face us when we attempt to prosecute high-level accused for international crimes in international courts. Now, first, by way of background, I would like to basically talk about briefly about the creation of the international courts that exist today. And then I would like to talk about some of the challenges that we face in putting these cases together and presenting them in these courts. I would also, finally, but not least, like to talk about what I believe are some of the legacies that these courts will leave when many of them close, because the ICC is a permanent court, but the other courts are courts of limited duration. And then at the end, I would very much welcome your comments and questions. The international community reinvigorated international prosecutions for international crimes in an international setting when in 1993, the United Nations Security Council created the Yugoslav court, the ICTY court, and very shortly thereafter, in late 1994, created the Rwanda Tribunal, the ICTR. And since that time, there have been various approaches taken to creating other international courts to try international crimes. As I said, the ICTY and the ICTR were created by the Security Council under its Chapter 7 powers to regulate situations that it believed were, in fact, threats to international peace and security. These courts had a very broad, and still have a very broad, personal jurisdiction mandate, basically to investigate and prosecute all of those who are responsible for serious violations of international humanitarian law. A mandate, I believe, was much too broad and led to unreasonable expectations on behalf of the various users or audiences that are impacted by those courts. The Special Court for Sierra Leone was a different kind of court, and it was created by virtue of an agreement between the United Nations and Sierra Leone. At the initiation of the government of Sierra Leone, it came into being in 2002. Its personal jurisdiction was much more restrictive and I believe much more manageable. The personal jurisdiction for this court is to prosecute those who bear greatest responsibility for the crimes that were committed during the conflict in Sierra Leone. This is a court that, unlike the ICTY and the ICTR, which are funded by the United Nations, the Special Court for Sierra Leone is funded purely by voluntary donations. There is a similar court that has been created, at least similar in the sense that it also involved an agreement between the United Nations and the country in question, and that is the court in Cambodia, the Extraordinary Chambers in Courts of Cambodia, that is dealing primarily with the genocide that was committed in that country. This is a Cambodian court that has international participation in the court. And finally, the International Criminal Court, which is a court that is a creation of treaties. And that is to say that it is a creation of member states joining in treaties and bringing this court into being. And it came into being in 2002. As of this month, in fact, there are some 114 countries that are member states of the International Criminal Court. And a controversial subject matter jurisdiction that this court has is the jurisdiction to investigate and try cases of crimes of aggression. This has recently been decided, a definition has been created, and investigations and prosecutions could begin perhaps in 2017 for this type of crime, but jurisdiction over these crimes is subject to many limitations at the International Criminal Court. So these are, in the main, the international courts that are today trying these international crimes. And now I would like to basically turn to the challenges that we face when we are attempting to put together cases and present them in these international courts. The challenges that we face are really the product of several realities in these situations. One of them is the scale of the crimes themselves, the magnitude of the crimes, the geographic and temporal environment in which those crimes were created. Also, the multitude of direct perpetrators of those crimes, the multitude of perpetrator groups, and the links in the chain that you must establish as you work your way up to trying to prove the liability of a high-level accused. And when you're dealing with high-level accused, another reality that you often face, as we did in the Charles Taylor case, is that you are prosecuting an accused who was never in the country when the crimes were committed, certainly not present when the crimes were committed, and of course himself was not a direct perpetrator of those crimes. You also have a reality with very senior level accused in that many of them hold high office and they're able to carry out activities in support of their criminal involvement, but under the cloak of official office. And so when you are investigating these crimes and putting them together, you have to bear that in mind. So these are the kinds of realities that lead to the many challenges that we face. And the first challenge that we face is how do you manage the expectations of the various user groups, the ones who are the recipients of the benefits of the justice that is to come from these courts. These courts are nothing more and nothing less than closed criminal justice systems. But the user groups often see them as very much more and expect much, much more from these courts than they are able to provide. Victims and survivors of these conflicts have many, many needs coming out of long conflicts. And they turn to these highly visible international courts very often to meet these many needs. But again, these courts are limited mandate courts, and they are unable to respond to many of the needs, legitimate needs, of these people. Now, the victims and survivors who come forward as witnesses turn to the courts to be provided with security and privacy, even though they step forward to be witnesses. And the courts do have provisions that allow us to respond to that need of those witnesses, and I'll touch on that a little bit later. They also turn to the courts for some support for them as they are asked to come forward and to relive traumatic events that most of us cannot even imagine. And here again, the courts are able to provide some limited support, at least before and during their testimony, in the form of medical assistance for those who need it, and also psychological counseling for those who need it to be able to come forward and relive these very traumatic events. However, long-term support to help them deal with the trauma, to help them deal with the flashbacks that often after they testify occur, very often the courts are unable to provide any meaningful support in this fashion to meet those needs. Many of these witnesses, indeed many people, look to the courts to basically establish a history of what happened in the country. And they expect that anyone who comes forward will be accepted as a witness to give witness to what happened. But of course, in reality, Only a very small handful are chosen to be witnesses, and we have to manage the expectations of those who saw the court playing a broader role in establishing the history of what happened in the country, and the expectations of the majority of the victims and survivors who are never called to come forward to testify in these cases. We also have to deal with the expectations of states, and their expectations are different, but the same picture emerges. Some of the expectations we can meet, many of them we cannot, all of them we have to attempt to manage. States want to join with these courts to contribute to a lasting peace in their country. But states, and actually international actors as well, often are of the view that these courts do not really contribute to a lasting peace. In fact, they're an impediment to political progress toward a lasting peace. Now, if we take that in the context of crimes occurring in a domestic setting, we would see how false that is. Because in your neighborhood, if your neighbors committed horrific crimes against you, took everything you had, basically shattered your lives, if you were told, just buck up, forget it, and move on, you wouldn't accept that. And yet very often in the international community, that's what we tell these victims and survivors. And states who may be governed by leaders of perpetrator groups often tell that to the victims and survivors in their states, and so see us as an impediment when we seek to have accountability for those crimes. The states also expect a degree of delicacy in our dealings in these countries in relation to very fragile institutions. And in many of these countries, there are now emerging democratic militaries, reformed police services, and they want us to be very careful in our dealings with these institutions as well. Sometimes we can do that. Other times we cannot, because the leaders of these organizations may in fact be suspects and turn out to be accused in these cases. Another very important area that states look to us, that we can in some measure meet this expectation, is to work with them to build the capacity of their institutions, of their judiciary, of their police. And to the extent our limited resources allow us to do it, we do indeed work with them in these capacity building exercises. We also work with them to identify other groups that may be able to come in and help them to build capacity within their countries. The expectations of the international community, which provides most of the money, all of the money really, for these courts, either through the United Nations or voluntary donations, basically wants us to be efficient and effective in investigations and in our trials so that we can have timely resolution of these trials and a timely closure of these limited duration courts. And they also, of course, share the hope of the courts that the end product of this process will be justice for the victims, for the survivors, for the witnesses, and also justice for the accused in the sense of fair trial proceedings for all accused. But the courts themselves also have some expectations of the international community which are not always met. Those expectations include the international community being committed to the mandate of the courts that it has created. And that commitment would manifest itself by turning over indicted persons, by allowing access to evidence, and also by providing sufficient funding to allow us to move forward and to complete our mandate. Civil society in these countries also have expectations of us that very often we cannot meet because of a limited mandate and limited resources. So how do we manage those expectations? The primary way that we manage those expectations is through various outreach programs, and I will talk to you a little bit more about those in a moment. Another big challenge that we face as prosecutors is how do we fashion the indictment? If we're dealing with high-level accused, the indictment is usually going to be an umbrella case, if you will. That is to say that it will be a case that incorporates perpetrators, actors from other cases, actors from various perpetrator groups, that incorporates crimes throughout a country and indeed for several countries. For example, in the Milosevic case at the Yugoslav tribunal, the actors in that case included Serb perpetrator groups, Bosnian Serb perpetrator groups, and he was charged with crimes that were committed by these groups in 3 different countries. In the case of Charles Taylor, the umbrella case involved major aspects of the cases against 2 of the 3 main perpetrator groups in Sierra Leone. And it also included crimes throughout the country, and in both instances, and in virtually all high-level prosecution, they include crimes over a very long time period. The magnitude of the criminal activity itself challenges you with the indictment. Tens of thousands of crimes, tens of thousands of victims, tens of thousands of perpetrators. Now, in the Sierra Leone court, we were assisted with this because we had a limited mandate in terms of our personal jurisdiction. In the Yugoslav and Rwanda tribunal, there were expectations in those countries that all of these offenders, or most of them, would be tried, and that simply was not something that could be done, which led to the people feeling let down, resentful, that somehow the mandate wasn't being fulfilled. Well, when we look at the crime base, the time period, the geographic scope of these crimes, how do we deal with that to fashion a suitable indictment? We really have 2 primary considerations. And the first consideration is that we want to fashion an indictment that will clearly and accurately reflect the scope and the seriousness of the crimes that we are accusing this high-level accused of committing. And we also want to have an indictment that will reflect the nature and the scope of this accused involvement in these crimes. Now, for senior level accused, again, this is going to mean that we will have a very broad base of crimes that we charge over a very long time period and over a very broad geographic area. That's one consideration. But the second consideration is that even with this in mind, we have to fashion indictments that are efficient, that we can prove beyond a reasonable doubt within a reasonable period of time. So those are the 2 considerations that drive us when we are looking to how we indict a person and what the indictment must look like. If we have an indictment, then how do we actually go about getting custody of an accused? These courts do not have a police force. They don't have a territory over which they have control. So they have to rely on states and the international community to take these individuals into custody and to turn them over to these international courts. There are many factors that delay or prevent these indictees being handed over to the courts. Very significant delays in many cases. For example, Mr. Karadzic, who was the leader of the Bosnian Serbs in Bosnia, was indicted originally by the Yugoslav tribunal in 1995. He was handed over to that tribunal in 2008. Mr. Taylor was indicted in March of 2003. He was handed over to the Special Court for Sierra Leone in 2006. President Bashir was indicted by the International Criminal Court, and an arrest warrant was issued in March of 2009. He still has freedom of movement to many states, even though they are in fact members of the ICC. Political sensitivities may play into this delay or this basically inability or unwillingness of states to turn these people over. States may be very concerned about the implications for the stability of their governments if they turn over a high-level accused, because they have many people in their countries that were supporters of the accused, that benefited from the conflict with the accused faction, and that now hold positions of political and economic wealth in the countries. You know, in the Taylor case, there was an asset freeze that was put into place by the United Nations. And at one point, the government of Liberia said, we really cannot put that into place because it would basically undermine our entire economy if we were to do that. There were so many people who had benefited from their association with Mr. Taylor that for Liberia to put it into place really was not an option for them. There may also be security concerns at the national level, at the regional level, at the international level that delay or prevent the handover of these indictees. In my experience at the Yugoslav Tribunal, my dealings with the Rwanda Tribunal and also in Sierra Leone, at the national level, these security concerns are not usually that well founded. There is some ripple effect of arresting these people and handing them over, but there are no serious security consequences for handing them over. But security concerns may also impact where these trials will actually be held or where the courts themselves will be situated. In Bosnia, when the ICTY was created, it was not possible to put the court in Bosnia. It was still a very hot war. There was no safe place to put the court. In Sierra Leone, it was determined that the court could be situated in Sierra Leone, and that worked very well, except for the Taylor case, where because of security concerns on the part of the Sierra Leone government as well as the Liberian government, that trial was in fact moved to The Hague. So these are the types of concerns that may undermine the ability or the willingness of the international community to hand over these indictees. I think the heart of the issue is how highly states and the international community value accountability and the rule of law over the many competing interests that they have. If they do value this and they want to hand these people over, it doesn't happen unless we have cooperation within the state and between states to actually get these accused handed over to the court so that they can be tried and their accountability can be determined. Now, even before we get to the issue of issuing an indictment or getting custody of the accused, we have a huge challenge to identify and select evidence and then to try to determine how we can get access to it. And each one of those has independent challenges. When we are prosecuting these types of crimes in these international courts, we have three broad categories of proof that we must meet the beyond a reasonable doubt standard for. The first category is one we're most familiar with, and that is proof of the underlying acts, the murders, the rapes, enslavement, those types of underlying acts. And we have to prove those beyond a reasonable doubt. Now, if we have a high-level accused, we are not required to actually prove the identity of the individual perpetrators of these crimes. In most instances, we have to prove the group to which they belonged because it's through the groups that we work our way up to the high-level accused to prove their accountability. We also have to prove beyond a reasonable doubt the chapeau or the common elements. And these elements are what would transform a murder, a domestic murder, into a crime against humanity or a war crime or genocide or other serious violations of international humanitarian law. And they carry many, many elements for themselves. And of course, we also have to prove why this particular accused is guilty of crimes where he didn't commit the crime, he wasn't present at the crime, he wasn't even in the country. Individual criminal responsibility. So when we are investigating, even if we believe the focus of the trial will be on this person's individual responsibility, we have to prepare to prove all three categories beyond a reasonable doubt. That leads to very lengthy and very complex investigations. The categories of evidence that we turn to are no surprise to you. They're the same categories of evidence that we would look to everywhere. In terms of witness testimony, there are provisions that under certain circumstances, we can actually present prior statements of a witness or prior testimony instead of bringing the witness in to testify viva voce in the court. When I talk about insiders, when I talk about insider witnesses, which are one category of witnesses that we deal with, what I'm really talking about are accomplices. And we look to accomplices, in particular, to develop the individual criminal responsibility of these accused. We also look to experts and what we call overview witnesses, people who, by virtue of their positions, can give us a lot of information about crimes throughout a country or about individual criminal responsibility over a long period of time. So overview witnesses become very important to us as well. In terms of documentary evidence or forensic evidence, one of the things we do not have to do in these international courts is to provide forensic evidence to prove the death of individual victims. We can do that by other means. Now, in Rwanda and also in Bosnia, they did have quite a bit of forensic evidence they were able to introduce in the form of mass grave evidence, exhumations from mass graves. In Sierra Leone, we have not had the benefit of that kind of forensic evidence. How do we identify and select the evidence? We have to have an efficient trial, but we have to prove everything beyond a reasonable doubt. So basically, we pick evidence that will give us the most bang for the buck, if you will. Evidence that will speak to many elements in all three categories of proof. And that's how we go about trying to build an efficient case, but one that will prove our case beyond a reasonable doubt. And in that regard, we do place a lot of emphasis on witnesses such as doctors or human rights workers, United Nations workers, NGO workers, who can give us what we call this overview evidence. In terms of the witnesses who can speak to the crime base, the witnesses who can speak to the individual criminal responsibility, again, we look for witnesses that can give us a little bit of everything. And when we are looking to crime-based witnesses, when we're looking to accomplice witnesses, we have to be a bit schizophrenic in our approach. And all of you who are litigators understand that quite well, in the sense that when we're speaking to a survivor who, as some of our witnesses have testified, one witness had to carry the severed heads of her children after she was captured and taken to another town. Witnesses who were the subject of gang rapes and then were held as sex slaves for years. Witnesses who had one hand and then two hands amputated. As a human being, your humanity reaches out to these individuals. As a prosecutor, you sit back and assess the credibility of what they are telling you. With these accomplices, and by the way, you know, I think as human beings, we sort of have this idea that the doers of evil deeds are people we can spot. We would just know that they do this. But of course, that's not true. And these cases prove it's not true. Very charming, very personable individuals come forward to testify who have done horrific things to people. And the humanity inside of you recoils from them. But the prosecutor in you sits back and assesses their evidence. When we are looking at documentary evidence, we are basically, for these high-level prosecutions, looking at documentary evidence that will prove the de jure or the de facto role or authority or participation of these accused with the criminal groups and the crimes themselves. When we're dealing with high-level officials, heads of state, former heads of state, and other high-ranking officials, we also have to look at how they may have used what I call diplomatic cover or official cover for their criminal participation. So as the president of a country, you may engage in activities that are part of your official duties, but you also use those activities to further the criminal participation. And so we have to be aware of this, and we have to have evidence that helps us sort out what is an actual official, legitimate official duty or task, action on the part of this accused, and what is being used as a subterfuge or a cover for the criminal environment. So once we know basically what we want, we have an idea of where we can get it, how do we get access to it? And that's another big issue that we have to face. And there are various factors that also preclude us from getting access or give us very limited access. One is really a personal factor. People may be very hesitant to come forward because they don't want to incriminate themselves. They may not be afraid of prosecution in the international courts, but they're concerned about prosecution in the national courts, and so they're reluctant to come forward. For victims and survivors, they may have security concerns, and very legitimate security concerns, and they won't come forward because of that. But we also have difficulties with access because of political agendas. States may be governed by people who were supporters or subordinates of the accused. States may be very concerned about how they deal with people in the state who, as I mentioned earlier, have tremendous political and economic power, and what will be the consequence of giving a court access to incriminating evidence. What will be the impact in terms of how these people may react in the courts? International or regional players may have concerns about coming forward because they don't want to risk what the appearance may be of their interactions with these accused or these perpetrator groups. Or they may not come forward for very legitimate concerns that they don't want the repercussions of basically disclosing what were diplomatic negotiations or diplomatic discussions. So these types of political agendas and political concerns will also very often prevent us from getting the best evidence that we need for these cases. Again, security concerns may limit access. The security concerns that I mentioned earlier may limit our access. So in trying to determine what evidence we need and how we get it, we basically have to keep in mind, what do we have to prove, what's our best evidence to do it, and what's the most efficient way that we can do it, given that we may have limitations on our access to the best evidence. Now, another one of these challenges that we have, and it is a critical challenge, because without witnesses, these trials do not go forward, these courts do not succeed, and that is, how do we give witnesses privacy and security? How do we do that? These witnesses live very often in areas where there is little or no rule of law. They live very often under the authority of hostile governments. They live very, very often among the perpetrators they're going to testify against, including the perpetrators who committed the crimes against these people. So that is the environment in which victims and survivors are living. For insiders, for accomplices, the risks are even greater. They too are living in this type of milieu. But they are seen as traitors, not only to the accused they're going to testify against, but to the group that they used to belong to. So it's with these kind of security realities in mind that we have to look at how we can give them protection. And protection for witnesses is the foremost consideration in any of these cases for the prosecution. And if we cannot afford to provide some type of security that we and the witnesses feel comfortable about, we simply do not call the witnesses, because we, in fact, are putting their lives on the line if we cannot provide them with adequate security. The protective measures that these courts provide are equally accessible to both prosecution and defense witnesses and are used equally by the prosecution and the defense. But even in this environment, these protective measures are not absolute, and they're not automatic. And we have to make a showing both at an objective level and a subjective level before we can get any of these protective measures for witnesses. And unfortunately, they do not always work to protect the identity of witnesses. The protective measures that we use include something as simple as using a pseudonym instead of a name, or having facial distortion or voice distortion when the witness testifies, or having private or closed session testimony so that the public is excluded from hearing what is happening. Now, the accused and their counsel are present for all of this, and the accused and their counsel know who these witnesses are. Well, as I said, most of these courts are courts of limited duration. So how do we go about protecting these people after the court goes away? When these courts close down, residual courts will stand up in their place, and these residual courts will have the ability to both investigate and to prosecute people who threaten or intimidate or harass these witnesses. But this is a crucial challenge that we must be able to meet in order to have any kind of success in these trials. The last challenge I would like to talk to you about is a challenge that is across the board for these high-level accused, and that is turning the trials into propaganda and political platforms for these high-level accused. These accused always have a much wider agenda that is a political agenda. And if you're sitting on the prosecution side of the room, it becomes very interesting in the courtroom, because on the defense side, you may have something like a revolving door, as defense attorneys actually walk out of the court, even after being told by the judges to remain, walk out of the court when they choose. Accused will also boycott the court by not coming to court, so that we have this sort of very, very high drama in the courtroom, which is really intended to divert attention from the evidence, to divert attention from the witnesses against the accused, but also to deal with this broader political agenda and to strengthen external support for this accused. We also get political histrionics in the courtroom. Again, not just on the part of the accused, but also on the part of defense attorneys. And if you are on the prosecution side, you had better have a tough skin, because you're going to be attacked both professionally and personally by the accused and by the defense attorneys. During the Taylor trial, I have been accused of more things than I can remember that would not only get me disbarred, but would put me in jail. And the prosecution team in Taylor has been referred to by Mr. Taylor as the American Goon Squad. So it's very interesting from the prosecution side. The challenge for the prosecution is to remain focused on the issues in the trial, the evidence in the trial, and what you have to prove, and to try to keep the trial focused on that as well. Now, this type of political and politicizing of the trial does not end in the courtroom. In fact, it also occurs outside the courtroom. In these international courts, there are codes of conduct for the counsel, and these codes of conduct carry sanctions for violations, and they very strictly limit what you are legitimately allowed to talk about to the public. If you are on the prosecution side, there are additional restrictions in that you may not comment on the guilt or innocence of these accused. The defense routinely ignores these codes of conduct in these cases and are very, very vocal with the press. And they come up with great sound bites, and they come up with great interviews. And then, of course, the press turns to us to ask us to respond. We don't get the get-out-of-jail card free for these codes of conduct, and so we are very much in a position of trying to determine how can we respond to this in a way that doesn't violate the code. But these are very political trials. They are very propaganda-oriented trials, and that is just something that you have to deal with and that you have to try to move beyond and keep things focused on the real issues in the trials. So those are some of the challenges that have been faced in all of these courts for all of these high-level prosecutions, and for the most part, those challenges have been met, they have been overcome, and these cases have moved forward. Many of these courts now are close to closure. The Taylor trial will be the last trial for the Special Court for Sierra Leone. So what are some of the legacies of these courts? And I would suggest that there really are several legacies of these courts. And the first legacy I'd like to talk about is the reality that these high-level prosecutions can be done. You can do them. You can get these accused. You can have indictments that reflect the nature and scope of the crimes, but also can be efficiently prosecuted. You can do this in a fair way, a way that is fair both to the accused and to witnesses and survivors. Now, of course, these are criminal proceedings, and they are for international crimes, so you would expect that another legacy will be the development of international jurisprudence, and indeed, that has been a very significant legacy of these courts, and there has been a substantial body of law that has been developed in relation to these international crimes. And you know, the devil is always in the details. And so what has happened in these courts when we have prosecuted these international crimes is that crimes that were set out in treaties and in customary international law have basically been refined and defined through the crucible of litigation during criminal trials. So that now we have a great body of law, for example, on genocide, which came out basically from the Rwanda tribunal. So how do we define the terms? What factors do we look at to prove the cases? What is the mental element, the mens rea for genocide? All of this has been developed through these international organizations and these international courts. Now, we benefit greatly from the academic work that precedes us and accompanies us through these trials. But we actually then apply that in a trial setting, and that's where you get the real refinements and the real definitions for some of these terms. Another area that we have developed substantive law is in the area of child soldiers. And this is a very important area because the use of child soldiers is very widespread in many countries. And the impact on children who are taken as young as 8 or 9 years of age, taken into these perpetrator groups and trained to fight, to kill, to rape, to maim. The impact on the children is tremendous, but the impact on the society to which they must ultimately return is also tremendous. The Special Court for Sierra Leone has developed a jurisprudence in this area and has both had indictments and convictions for this crime of the use of child soldiers, children under 15 years of age. Yet another area that we have developed jurisprudence has to do with sexual violence in these crimes against humanity in conflict. And one of the things that the courts has done, perhaps the most important thing that it has done, is that it has made clear once and for all that sexual violence is criminal conduct. It is not just good old boys coming home from a hard day at war or crimes against humanity. These are crimes. They will be prosecuted as crimes and convicted if the evidence is sufficient. And 2 of these crimes have been developed, again, at the Special Court for Sierra Leone. The Special Court for Sierra Leone has recognized the offense of forced marriage as a crime against humanity and has also developed the jurisprudence for the crime of sexual slavery. Both of these were very key conduct that occurred during the war in Sierra Leone. The courts have also defined the parameters of the fundamental rights to which each accused is entitled and the oft overlooked and forgotten rights of witnesses who come forward, the right to security when you come forward to testify, and has also provided guidelines to tell us how do we balance these rights. The right of the accused to a fair trial is always paramount, but when we look at what we mean by a fair trial, we have to include considerations that include the protection of witnesses who come forward. So these are some of the areas that the jurisprudence has been developed. Now, associated with the development of this jurisprudence has been the evolution of protocols, of policies, of standard operating procedures so that we prosecutors can efficiently and effectively investigate and prosecute these cases. And now, I think at a time that is long overdue, the international prosecutors are now preparing a best practices guide for the prosecution of these cases. And we're hoping that this best practices manual will be finalized in May and to be made available to the international community. Again, I think that is a long overdue development, and I'm very happy to be part of that. Another one of the legacies has to do with these outreach programs that all of the courts have to a greater or lesser degree. And as I mentioned earlier, the outreach programs are the primary vehicle by which we can manage expectations, but also keep these various audiences, these various users, updated on what is happening. Many good things have come out of these trials. First of all, the courage of witnesses and protective measures have given witnesses the confidence to come forward, and that has happened. Both the prosecution and the defense have been able to very vigorously advance their cases, and the courts have respected and protected the rights of witnesses and the accused. These are very important messages that need to be sent out to the civilian populations and the governments of the countries in which these crimes occurred, and also to the international community. And these messages have been sent out in a variety of ways, all the way from personal visits to villages and towns in the affected countries, to conferences internationally, to live streaming of the testimony of these proceedings, to summaries across the radio in these countries, various ways to get the message out and to keep these users updated as to what is happening in these proceedings, in this search for justice and accountability for these very serious crimes. But perhaps the ultimate legacy, the most important legacy, the one on which we should pin all of our hopes, is the legacy that there is no longer impunity for these types of crimes. That no matter your position, your power, or your authority, you will be held accountable for these crimes, but accountable in the rule of law, accountable in a court that acts impartially and independently. This is a legacy that carries with it both concern and hope. The concern is that this legacy will in fact be cast aside by the transcendence of what some people consider to be the needs of realpolitik. But the hope is that by meeting these challenges, by bringing these cases forward, and by letting people know what has happened, the good things that have been done, that this legacy will carry on forever, and that impunity, in fact, will no longer exist, and we will even broaden the scope of the people that we can bring before these international courts for these international crimes. So those are some of the challenges, some of the legacies, and I would like to thank you very much for allowing me to come here and speak with you about them, and I would also invite your questions and your comments. Thank you very much.
Microphones that will come around to you. So just once you've been identified, wait for the microphone. Anybody want to start us out? This is usually not a shy group.
Do you want me to tell you a little story about Naomi Campbell? We were of the view that Naomi Campbell would basically tell us what her agents have been telling us she would, and that is that indeed in South Africa she happened to be at a dinner party that Charles Taylor was at, and that during the dinner party he told her he was going to give her a rough diamond or rough diamonds, and that afterward he actually sent people and she received the diamonds from him. Now, we had gotten this information from a source who was actually involved in giving her the diamonds. So we knew that that was the story. But just a couple of days before she came to testify, we got a hint from her agents that maybe she wouldn't tell us that. And so her story at trial was very simple. She was at this dinner with Charles Taylor. Nothing happened. There was no interaction. And then after that dinner, late at night, at the guest house of President Mandela, these strangers appeared very late at night, came to her room. She didn't know how they came to her room, and they gave her some dirty pebbles. And they didn't tell her what they were, or who they were from, or why she was getting them, but she took these dirty pebbles, and instead of saying, what do I want with dirty pebbles, and throwing them in the trash, she kept them. And then the next morning, she thinks that either her agent or Mia Farrow told her, you know what, I'll bet those dirty pebbles are diamonds, and I'll bet Charles Taylor gave you those. Now, how they would know this, she doesn't explain, but they're the ones who told her this. And so she kept the dirty pebbles and indeed handed them over to a gentleman in South Africa because she didn't want to have dirty pebbles, I guess, when she left the country. That was her story. Not plausible? I think not plausible. Mia Farrow testified and said she came to breakfast the next morning very excited and said, Charles Taylor gave me a huge diamond. A bit of a different story. Now, after she testified, and by the way, quite sadly, when she testified, there were probably over 200 media representatives in the courtroom. When the victims came forward, who had been the victims of multiple rapes, of horrific crimes, of amputations, we were lucky to have 3 or 4 members of the media in the gallery. But there were a lot of media. So there were TV trucks and all these things outside. So the next Monday, when I was coming to work, I stopped at the Total gas station, which is where I buy my sandwiches and Coke. And the lady that was working there, I said, so did you see all of these vans over by the court last week? And she said, yes, I did. And I saw that lady testify on TV, because apparently the Dutch TV ran excerpts of it. And I said, well, what'd you think? And she said, I think that lady was lying. So this woman knew nothing about her case, knew nothing about this lady, but she thought that she was lying. Naomi Campbell, I think, did lie. And she later had an interview in, I think, British GQ, and basically admitted that Charles Taylor had given her those diamonds. So Naomi Campbell, who was inconvenienced by coming to court, was quite thrilling for everyone. All of the men in my office certainly wanted to be in that courtroom when she testified, and were. But I'm afraid that she didn't give the judges the full benefit of the truth about what happened after that dinner in South Africa. So that's Naomi Campbell.
Why, in light of those challenges, why were you using her as a witness?
We felt that we had to call her because she was the one who actually received the diamonds. And as I say, when we initially contacted her agents, the feedback that we got from them was that basically she would be giving the same details that the others would. And it was only after she had been subpoenaed and was due to testify in a couple of days that we got an inkling that maybe that would not be her story. So, and the person who actually had the best knowledge of it, who was involved in giving her the diamonds, we were unable to call because of security issues. Yes, sir.
Colonel, could I follow up on the last point you made about real politics? How do you respond when they say, to use a very current example, threatening Gaddafi with international criminal prosecution will simply cause him to dig in his heels, fight harder, cause more casualties, commit more crimes? How do you respond when they make those real politic arguments?
Well, I think that may very well be true, but I think that's really irrelevant as to whether you would prosecute him or not. I don't really like threatening prosecution. I like investigating and then indicting if you have enough evidence. But he may very well do that. Charles Taylor was accused by the international community for years of being involved in the crimes in Sierra Leone and simply denied it and continued to provide support for them. Our evidence is that in a 2-year period alone, Charles Taylor received over 5,000 pieces of gem quality diamonds from Sierra Leone in return for his support for the people in that country. People feel that you're not going to catch me, you're not going to convict me, and I can make so much out of it. It is so beneficial to me in so many ways that I'm willing to take the chance. Because what are the chances that I will be indicted, that I will be handed over to the court, that they'll be able to prove the case against me? So it may very well be that that would exactly be the response. But again, I don't like threatening prosecution. I like investigating and then indicting if you have enough evidence. Yes, sir.
You mentioned that the court was going to be closing, the International Criminal Court was going to be closing. What impact has the courts had on reducing crime?
The International Criminal Court is a permanent court, but the Special Court for Sierra Leone will close. The ICTY and the ICTR will close. You know, that's an interesting question that we also talk about in the context of domestic crime. And in my view, it may have very little impact on leaders. Hopefully it will have some. Hopefully they will think twice before they commit these crimes. But I think they're still very much of the view that they can commit these crimes and get away with them. But it does have impact on the individuals that we indict and put in jail. And one of the things it does is that if they have committed these crimes, they're indicted, they're convicted and put in jail, it removes them at least from direct participation in the region to further destabilize it. Now, that's not the reason that we carry out these prosecutions, but it is a consequence of convictions in these cases. But I also don't believe for domestic crimes that prosecuting people is much of a deterrent to others. We always think we'll get away with it.
You mentioned that after the special courts leave, there are residual courts that take over. How effective are these residual courts at, say, protecting witnesses that have come forward, and how do they function?
Well, we don't know because the Special Court for Sierra Leone will be the first one that actually transitions to a residual court. But one of the measures that we have insisted on, and that will be part of the residual court, is that we will actually have people in Sierra Leone, victim and witness representatives, who will be there so that witnesses, and by the way, confidential sources are also included in this, will have a very quick and effective means of letting people know, I'm being threatened, I'm being harassed. So keeping people in country, I think, will be key to the ability to effectively respond to threats. And that is one of the ways that they'll do that. And of course, they'll be able to try people who are guilty or accused of threatening, attempting to bribe, intimidate witnesses. They'll be able to try them and actually put them in jail as part of the punishment for such conduct.
What type of security do you have when you're going out to investigate all the evidence? Like you're going out to see the fields where the genocide occurred or whatever, and outside the courtroom.
I have the security of being on the right side of the law. That's the only security that we have. We don't carry weapons. When I went to Bosnia, after I-4 went in, we did have 6 members of I-4 that came with us when we were in the field, and it was a good thing because during that trip, I had an AK-47 put in my face, and let me tell you, the barrel of those guns, the bore is about that big. And we also were threatened by local leaders, but for the most part, we have no security when we go out.
Question was a two-part question, but I wanted to give this gentleman a chance. But you mentioned that the first court was set up in 1993. And my question is, was it modeled? How was it modeled? Was it modeled after, where was it modeled from when you set the first court up in 1993? And what is your model? What do you use?
I think we have someone in the audience who would be a better place to talk about that, and that would be Michael Scharf himself. I got involved in the court once it was created. Now, the Secretary General was ordered to look at what crimes we should have jurisdiction over and to look at crimes that, without a doubt, had become part of customary international law. So in terms of jurisdiction, that was what he was told to look at. But what it was modeled on, I think Michael could better answer that, because I honestly don't know if there was any model.
Just briefly, we dusted off the old 1945 Nuremberg Tribunal Charter. We added the Covenant on Civil and Political Rights to it, and voila, you have a modern international tribunal.
And the organization of the court was also modeled after Nuremberg?
That came from a variety of different proposals from different governments, and it was sort of a hybrid, and it was mostly a compromise.
You know,
we have time for one last question.
For an international prosecutor, much like for domestic prosecutors, but it must be a little bit different for you, who is your client, or who do you go to if you need to run something by somebody and say, should I do this? Do I have authority to do this? Is this the course you want me to follow? I know that's tough for prosecutors generally. How is that for an international prosecutor?
It's a very good question, because one of the allegations against the prosecution, the Office of the Prosecutor in the Taylor trial, was in fact we were going for instructions to outside sources. The statutes in these courts make it very clear that the organs are independent organs, and you are actually prohibited from seeking instruction or taking instruction from anyone outside. That doesn't mean you can't take advice. And many of these offices of the prosecutor have legal advisory sections that we deal with. We also have legal consortium that we go to with questions. Michael's group have been involved in different questions of law that we have had, and we deal with it internally. Whether we should indict or not indict is purely a decision for the Office of the Prosecutor, for the prosecutor, and no one advises the prosecutor on that. So we reach out to academics, to other sources to interpret and apply the law. But in terms of how, who we indict, how we conduct our cases, that is purely within the Office of the Prosecutor, and it's decided by the prosecutor.
Let me just close this up then.